what he is saying is palatable and how much of it or what he is telling you is not going to be palatable or cannot be believed even by commonsensical standards. So each client always thinks that, if I say that this part of my case, which I think is weak, if I tell that, but I did this or I wrote this letter in which I made this admission, then he may not take up my case or he may think less of me. And therefore I'd rather not tell him those inconvenient truths. So those are the areas which experience will teach you. You will know by sheer experience when to believe your client and when to tell him, don't bullshit me, this could not have happened. Now come on, get on with it. I'm not a fool. And sometimes these things, when they are anticipated at the right time, before even the pleadings are drafted and prepared, often stand you in good stead. And the reason is simply this, that never ever underestimate your opponent. If you are going to court, go into court believing that your opponent is going to do a far better job than you can do. The reason is simple. Just as you are paid fees to argue your client's case, he is paid fees to argue his client's case. He is not going to come there with a white flag and wave it in front of your eyes. He is going to try and do the best possible that he can to convince the judge or judges that the justice of the case lies on his side. So, you better watch out. In other words, you better be prepared for every eventuality, factual as well as legal, that you are likely to encounter and deal with it right at the beginning. And that's why you need to know that there are no pre-prepared problems given to you. It's what you will put into the draft. It is whether you are preparing a defense, and even worse if you are preparing a claim or a petition, which is where you create a cause of action. You have to anticipate everything that is likely to happen. So that's what I wanted to just emphasize, because what you people are used to so far is somebody else drafts a problem, gives it to you, and then you work on it over a period of time and prepare the memorial and do after the research is done and all that. Which I said is not, it's creditable. You are getting an opportunity to try to make the best of it. But that's not the real world. So, one thing I also wanted to tell you was that it must have occurred to many of you as it occurs to me, that why is it that in a moot court competition, where the problem which is given to the teams which are competing, which is going to be the same, whether there are 10 teams, 20 teams, 50 teams or whatever. But why is it that there is only one winner? Have you ever thought of it that way? Why is it that one team wins and takes the prizes? Now, if you think about it, the problem is the same. Each team has read the same problem. Each team has by and large done the same set of research. Each team has prepared a memorial as best as you can, because now you people have access to so much more than we ever had thanks to Google and whatnot. So, and of course, people like Sonali or others you can go to, you can seek guidance and you can work on it. The professors will be there, others who have done moot courts in the past will be guiding you, etc., etc. And of course, from the experience which you have. But yet, there is going to be only one winner. So what does it tell you? What should it tell you? What it should tell you is that the team that is better prepared, that has done better research, and that has got a better understanding and the better oratory is the team that will win. And that is why the subject of today, which deals with basics of oral submissions, to some extent is related or relatable to what happens in actual life. In actual life also, the one who is better prepared, has a better understanding, has understood the problem better and presents it better in the sense that he is able to swing the justice of the case on his side, is more likely to succeed. So this is the stepping stone. This moot court competition should be taken as a kind of a stepping stone to learn these basics, which will ultimately stand you in good stead if you were to join a profession. So let me now begin by telling you that many years ago, now I'm getting into a generalization which applies, as I said, both to moot courts to some extent or a large extent, as well as to the practice of law in courts and how to be better prepared. William Shakespeare had written, as you know, many plays. And in Henry VI, in Part 2, Act 4, Scene 2, he has said, "Let's kill all the lawyers." Now this is very often quoted and very often misquoted or misunderstood. What did he mean? Did he mean that he had a loathing in that sense for lawyers? Did he really mean that he wanted lawyers killed and he felt that we were in some form or the other some evil force that operates in the world? On the contrary, what he said about let's kill all the lawyers is not the full quote. The full quote is, the first thing we do, let's kill all the lawyers. But who said this and in what context? He said it, the person who said it was Dick the Butcher. And he was a follower of a rebel called Jack Cade. Henry VI was the king at that time. And Dick the Butcher, who thought that if he disturbed the law and order, he could become king, or rather the rebel Jack Cade could become king, suggested to Jack Cade, the first thing we do, let's kill all the lawyers. And what he really meant was a compliment to attorneys and judges who instill justice in society. So they, or we, or you people who are going to be entering the profession are therefore the sentinels of justice. And that is why we are loathed, we are looked upon by people in authority and those who wish to bend the law, not respect the law, with a certain degree of hatred, to the point where somebody like Dick the Butcher would say, first of all, let's kill all the lawyers. Now, I don't want to get into a political debate over here, but you must be seeing all around you today what is happening around us and how certain liberties are being eroded, and who is the one who is standing in the way of those liberties being eroded or those freedoms being taken away, except the lawyers. So it is an important lesson to learn that as and when democracy is in peril or democratic principles or values are being trampled upon, it is we lawyers who ultimately will stand in the way. And that is why today we are hated. Government today constitutes more than 50% of the litigating matters which are in court. It is in more than 50% of the cases on one side or the other. Now you can imagine how hated we must be, because actions of government are being constantly challenged and are likely to be set aside. Now when we say that judges and attorneys or lawyers are the ones who instill justice in society, what does it mean? What does it mean? in order to understand that, you must understand that there is a difference, a basic and a fundamental difference between law and justice. So let me read to you a definition which brings out this distinction. While the two are strictly connected, they are not the same thing. Justice is a broad concept that is based on equality of rights, fairness, and morality. Conversely, law is a body of regulations and standards set up by governments and international bodies and is or should be based on the idea of justice. Law is an abstruse political construct couched in verbiage that seems to convey great meaning and clearly defined rules. It is, however, just words and conventions documented and set in a framework that is more or less static. Human society is not static. It is dynamic, ever-changing. The mores of a decade ago can become blasphemy in another decade. The ecological, urgent, biological needs and exigencies created by a transforming planet itself may necessitate that laws be altered with time. They are too, but much more slowly than is required, that is alteration. This is its greatest failure. Also, laws have come to represent the decision-making machine of the state rather than the will of the public or the citizen. Now, what does all this mean? Ask yourself a simple question. Even when you see two friends or two siblings having a fight or having a quarrel, they will appeal to an elder, maybe the teacher, the parent, or some other executor or elder brother, and say, tell her or tell him, this is not fair. Now ask yourself a simple question. Where did this 2-year-old get the concept of fairness? A child cannot read, the child is not educated, the child did not learn in the womb, the child was not taught anything, he barely can speak, and yet at that early age he has a sense of justice, he or she. So fair, when you talk of fairness, rights and morality, it is not that the law tells you that, it is ingrained in all of us. It is part of our DNA. And therefore, when you talk of law, it's one thing. When you talk of justice, it is quite another. So, when you present a case, when you're talking of making oral submissions, when you're talking of presenting a case even in a moot court competition, always remember that if you do not get to the nub of the case, if you do not understand common sensically, where does the justice of the case lie, you will never be able to be that better orator or the team that won the case. Very often we find in moot court, by the time, because I have always judged semi-final rounds, by the time the teams come up to the semi-final round, they have the problem rote-like, parrot-like by heart. They have the arguments by heart. They have probably done this so many times over that they have lost perspective. They forget the fact that they are before a set of judges who may not have even read the problem, or somebody might, like me, may have just about skimmed through it early in the morning before I come and sit here to judge the problem. But as we are trained lawyers and as we learn from experience, we can tell that an argument which is being made before us is either just, either fair, or it is not just or not fair, or will not do justice at the end of the day. Now, fortunately for you people, you have to be judged on your performance. You don't have to decide the problem. You don't have to give a judgment. So even though you may be going hopelessly wrong, the way you present the problem, the conviction with which you may argue, may win you more marks than your opponent, because we are now comparing A versus B. In a real court of law, it's not a comparison between Sonali Mathur and Shilpi Jain, who are both present here and both happen to be engineers at some point or the other. So it's not a question of whether she did a better job or she did a better job. It is decided on the basis of where does the justice of the case lie. Law everybody knows. The law applies equally to all. And yet, one will win and one will lose. And I am now talking in real terms in a court of law. So we call them courts of law, but they are actually courts of law, justice and equity. So don't ever forget the fact that you have to weave into your arguments, whether in a moot court or in a court of law, principles of justice, principles of fairness, principles of equity. Even a child can tell you, this is not fair. You gave him half a glass and you gave me quarter. I am a brother, I am a sister, I should get the same half. Now you should be able to point out why it is quarter and why it is not half. If you can do that, you will succeed. So please try and understand, therefore, when I say better understanding of the problem, I don't mean better reading of it. I mean a better mastery. In the sense, you should be able, and that's why you find judges will often throw you off with questions which you may never have thought of when you are preparing for the moot court problem. Because we don't ask you from 500 cases that you have put into your memorial. We ask you from the back of our head because something doesn't click, something doesn't sound fair, something doesn't sound just. And therefore, very often, moot court problems and the way the memorial is prepared and the research is done may not be able to address a question raised by the judges. And that's where, very often, after the competition, I said to the students, never skip answering a judge. Never worry about time. Because if I have asked you a question, I demand an answer. I ask you a question because I want to see how you can think on your feet. And I ask a question because something is not sticking in my mind. Now if you think that, look, I have got 10 minutes, this chap is asking too many questions. If I don't finish, I have got 3 topics to cover. Where the hell will I be? I think my point 2 is better than my point 1. I better jump to point 2 now. I'll just give a off-the-cuff answer. Don't ever do that. Because the judge who will ask you that question will factor in the point that he has asked you a question, he's eating into your time, and he wants to see how you perform. So that's the other thing you may bear in mind, and that's the thing that happens in court also. A judge will always throw you off by asking you a question, and sometimes it may sound very stupid, but you can't make an expression which makes the judge feel that it's a stupid question, unless you want to lose the case and you want the client not to pay your fees. But otherwise, the best thing to say is, Your Lordship is absolutely right. That's a very good question you have put to me, and then attempt to answer it without making it look stupid. So, these are the tricks, these are the things which you learn from experience. So, I just thought it would be important for you to know that when you are dealing with a moot court problem, don't look at it only from the point of view of what is the law applicable to this. Let's just research, get on to Google, get 200 cases, stick it into a memorial. After all, we are getting 15 marks for the memorial. In this, it may look good and bulky. So, since the problem we are talking about is oral submission, bear this in mind. This is where your auditory skills will come in. Then, What is the importance of law? When you talk of law and justice, and the two concepts being complementary but not the same, what is the importance of law in society? Why is it important to understand? The importance of law, again I'm giving you a quote, the law is important for a society for it serves as a norm of conduct for citizens. It was also made to provide for proper guidelines and order upon the behavior for all citizens and to sustain the equity on the three branches of the government. It keeps the society running. It's very important to understand this. Take for instance a simple example of driving on the left-hand side of the road. That's the law. Do you respect the law? No parking sign is meant not to park. Are you respecting the law? Going into a no entry is a crime. Are you respecting that law? So these are the things, wearing a helmet on a two-wheeler. These are the laws which are the guiding principles. They are done in order to keep society running and to bring order in society. Now, what is the difference between law and order? You must understand even that difference because it helps you understand the concepts which you are dealing with when you practice law. Law is a set of rules containing things you can and cannot do. So you lay down for your children a rule. You will go to sleep by 8 o'clock. And that's a rule. One child is allowed to watch TV. The other sibling will say, that's not fair. He was allowed to watch TV. So you lay down a rule, you lay down a law, and you preach it. Then your own child will tell you, that's not fair. So that's not justice. That's not obedience of the law. So law is a set of rules containing things you can and cannot do. This is not a perfect definition because the definition of law differs according to the school of thought you adhere to. But you get the general idea. Order is a condition where law is adhered to. I'll repeat this. Order is a condition where law is adhered to. What does it mean? If everybody drives on the left-hand side of the road, there is order on the road. There is order in society. Because it's a condition. People follow the law. So there is order in society and it keeps society running. You are driving on the road, you don't expect a guy to come at you from the wrong side. He is breaking the law and he is creating disorder in society because the first thing that will come out of your mouth is an unprintable. So this is how order in society is disturbed when law is not observed. So why am I raising these concepts of law, justice, equity, fairness, morality, law and order and all these things? The reason why I am raising it is because I am reminded of what Mickey Edwards, an advocate and a member of the US Congress, told students who were going to embark into a career of law. So he was speaking to law graduates like I would be speaking to you all. And what did he tell them? It's very interesting. And I'll quote, whether you are a prosecutor or a defense attorney, whether you advise corporations or sue them, whatever your daily practice is like, defending the rule of law, defending due process, defending the liberties of the people, and seeing that justice prevails. See the contradiction in that sense, law and justice prevails. He didn't say law prevails, justice prevails. That is no longer somebody else's responsibility. You are the champions of the law. And if you don't want that responsibility, you've chosen the wrong profession. Very, very powerful words. So why do I bring this up? Because we become the guardians of law. We become the guardians of justice, and we become the guardians of society. That is the responsibility that the law degree is conferring upon you. And that is the responsibility which you should understand you bear when you step out of this law college and get into the profession. So this is an important aspect to keep in mind. And if you understand these concepts, it will help you not only in your moot court competition, but it will help you also in real life. Now I'll just briefly talk to you about what are the attributes that I consider relevant for a successful lawyer. And here I mean a counsel who practices law in a court of law, as an advocate. As I told you earlier, right from the drafting stage, when a client comes to you, you need to know how best his case will be presented as and when it is argued later in a court of law. Now, a pleading, therefore, is the most important document that you are going to prepare. Why? Because it's the foundation of the case. Whether it's a defense or whether it's a complaint or petition. As you know, any superstructure built on a weak foundation can never stand. Similarly, however skillful you may be as an orator, however good you may be at your sense of justice, at the sense of equity and fairness, however well you may ultimately convince or try to convince the court, if your opponent is smart, first thing he will do, look at the pleadings and say, I'm sorry, that's not part of the pleading case. And before you know it, you're out on your backside and your client is lost. And you can do nothing because the case once pleaded has to be good till the Supreme Court. So never ever underestimate the value of pleadings. And that's where moot courts and real life do not coincide. Because in real life, it is your problem to draft the correct pleading, not somebody else's. And it's just not a hypothetical question, it's going to be the real question, which is going to determine the fate of the client in the matter. So what are the tricks? What is it that you have to do when you are drafting a pleading? The first thing you have to do is anticipate. And I've said this before, and I don't mind repeating it. In the architectural world, or in the hotel industry, they say there are 3 words which will determine the success of a hotel. And the 3 words are location, location, location. In our profession, there are 3 words which will determine the success of a lawyer and his case. And that's anticipation, anticipation, anticipation. If you do not take the trouble of anticipating every possible argument that is likely to be raised in answer to your client's case, you have not built the strong foundation that is required for the superstructure. So when somebody tells you, here is the case, here are the papers, draft a plaint, or here are the papers, draft a defense statement, or here are the papers, draft a petition, you don't have to just collate all the documents, put them in chronological order, kind of briefly refer to each one, what it says, put in some grounds and put in the prayers. I mean, you can do it, but then I can assure you, you're not going to get very far in the profession. So anticipation is important because right from who will be the parties to the cause of action, to what are going to be the facts which are relevant, to ensuring that you do not suppress a single material fact, because suppression of a material fact amounts to a fraud, and a fraud of the court disentitles you to relief at any stage of the proceeding. So please don't as I said, a client who's overwise or over smart and says, don't refer to this, it's going to go against us, keep it aside. We see if the other side is smart enough to catch us. Never accept that. Never. He is doing an injustice to himself, and you'll be encouraging him because you are doing an injustice to yourself. So anticipate, deal with it. Yes, it may be inconvenient, but there is always an answer. I can assure you of that, and experience will teach you that there is always an answer. So be smart about it, don't hide it under the carpet. So inconvenient truths, however they are, however much they may look like, deal with them. That's one. Second, in drafting the cause of action, let me tell you, it is far easier said than done. And I can tell you, after 42 years of practice at the bar, even today, I find this the most difficult job of a counselor. Because you are always, if you are a good counselor, if you really want to do justice to the case and to the client, even in the middle of the night, it might occur to you, before the draft is finalized, oh my God, I never thought of this. So you have to anticipate what is going to come from the opponent. And what I said earlier, never underestimate your opponent. Please think that he will do a better job than you ever anticipate. And he might think of things which you may not have thought of, but you can only think of what you can. So you do your best. As my father used to say, if a solicitor comes to you with a brief or a client comes to you with a set of papers, he comes to you knowing where you stand. If you wanted Palkiwala, he would have gone to Palkiwala. If you wanted Chagla, he would have gone to Chagla. So don't worry too much. Oh, but at my stage, I can't think like Mr. Dwarkadas and Chagla. Don't worry. He knows who is coming and what he is going and what he is going to get and expect to get. So you can only think up to the best of your ability. But give it a shot. Don't give up. And that's where building a cause of action is important, because you have to anticipate not only what the client would like the court to believe to be his case and where the justice lies, but cover up every possible defense that is likely to arise. And that you can only do if you are good at anticipating and you train yourself to anticipate. Equally, the prayers, the reliefs. Don't ever think, oh, it's all there now, it doesn't matter, a little bit here or there. No. There are matters of high stakes which have been lost or won only on the basis of a badly worded pleading and a badly worded prayer. And very often you will find that the argument is, but that's not the relief. Let me give you a very recent example. How many of you looked at the judgment or what was reproduced of it in the newspapers today? Justice K.M. Joseph's judgment in the review petition that was filed. He has said in the Rafale that we are not going to review this judgment. And one of the reasons he gave is Mr. Prashant Bhushan has not asked for this relief. Can you believe it? This is the highest court of the land, as recent as today or of yesterday. Relief denied to a PIL petition filed on an important question of law only on the ground, one of the main grounds being, yes, but Mr. Prashant Bhushan argued this, but that's not the relief that is. Please look at the judgment of K.M. Joseph, you will find it there. So I am just telling you why it is important. Why it is important to anticipate, and why it is important not to treat any full stop, comma, or any part of the pleading as taken for granted. The next, of course, which I have always again emphasized very, very much, is psychology. Now, why do I say that? Because ultimately you are arguing before a human being. You are not arguing before a computer or artificial intelligence. It's not as if you feed in a problem and you get an answer. That's not the way it is. So, and it has been said again very, very often and repeated again recently by Justice Nariman as of yesterday, we are all human beings. We have the same failings. as any other human being have. But we have to attempt to do justice at the end of the day as best as we can. He said it in the supplement of the case. So what I'm trying to say is that ultimately even judges are born with prejudices, with predilections. In the Supreme Court for many, many years, there used to be a judge called Justice A.S. It was well known, and I don't mean it disrespectfully, that he was what is called a pro-tenant judge. So any matter that went up between landlord and tenant, the landlord could take it, he lost. Now, this is a predilection. It's something that is a part of a state of mind. Maybe his landlord was a very cruel man and maybe shutting off the electricity or lift or water or whatever, denying parking or God knows what. But he had a certain prejudice against them. So this is what happened. So psychology comes into play because you must know your judge. And you must know how to play on that psychology ultimately, not because you are trying to abuse that position, not because you are trying to take advantage. But if there is a balance, if the case is hanging in a balance, it makes a huge difference if you are on the wavelength of the judge. And that's where psychology comes in, where you can anticipate how the judge is going to react to a particular problem and deal with it. So you have to therefore know this, and you have to have, where do you get this knowledge from? You get it from experience. So experience, knowledge, practice, and success, they are all the chicken and egg formulas. Which comes first, nobody knows. But you have to have experience to learn psychology, to learn the art of pleading, the art of advocacy, and if ultimately this comes to you only if you are successful, so where do you break that chain? But it will happen, you needn't worry too much. It will happen as you would have found your first moot court versus your third moot court or your fifth moot court. No more experience. You're able to anticipate better. You're able to understand better. You're able to present your case better. The next is perseverance. Now this is a very important aspect because very often we have seen in front of our eyes counsel who have the ability, who were excellent, who had the knowledge, who had the gift, but had taken a policy decision in their mind. This is how far I will go. If the judge does not understand, it's not my problem. And stop. That's doing a great disservice to your client. Because if you persevere, if you don't give up, if you try till the end, you never know what can happen. We take the Supreme Court. I know many of you may have been there, many of you may not have been there. Let me give you a very small example. I'm just to give you an example. The days on which the Supreme Court hears what are called special petitions is every Monday and Friday normally. There are 50-60 cases before each bench. You get half a second, maybe 2 minutes, and if you're very lucky and very perseverant, you may get 3 minutes, 10 minutes. But the point is not that. There was one particular case where Mr. Narayana was dealing with in the Supreme Court, and the other side had filed a special petition, and the judges were not at all with the appellate, and within no time they said sorry and put the papers down. And the lawyer, of course, persevered, he continued, and they said, no, sorry, Mr. Counsel, we don't find anything in this matter. He kept on, and Mr. Nariman kept on saying, obliged to rush. Of course, and he kept bowing, and he was trying to rush to another court. So I took it as a sign from him that he didn't want us to hang around so that the other side gets an opportunity to continue to persevere. So I also started backing up. He looked at me with dagger eyes and said, just stand here. Don't go till the next matter is called out. You never know what can happen in this court. That's the point I'm making. That lawyer persevered. He kept on at it till the next matter was called out. Even then he continued. Even then they kept on saying sorry. And finally when they said, Mr. Counsel, I think you must stop now. We've heard you enough, is when he finally stopped. But according to Mr. Nariman, with his experience, he felt that things could change. And judges could change their mind even at the last minute. So that's the importance of perseverance, and it's really a very small example. The next is preparing for a case. Whether you're preparing for a moot court, whether you're preparing for a case in court, I always tell the clients, preparing for a case is like preparing for war. Strategy is very, very important. And when you talk about strategy, whether it's for war or for a case, that strategy involves, again, the element of anticipation, but it also involves playing the chess game till the end. Why do you think, and what is it that you think makes a difference between a grandmaster and an ordinary chess player? A grandmaster can think up to the next 60 moves. If you move one pawn from this place to this place, he can anticipate all the combinations that will follow thereafter based on that one move. So if you are going to make the next move, which is going to come from, say, the pawn in front of the knight or pawn in front of the bishop, he would have thought, okay, now he's got this opening, so his next move would be this, to which my move would be this, to which my... This chess game has already been played in his mind till checkmate. That is what you mean when you talk about strategy. You have to anticipate the end result, the end game. And that is why you go back to point one, the pleadings, the parties, the call of action, and the relief. All these have to tie up to become one complete whole, which is like a chess game, where you have to anticipate every move of your opponent and be able to counter it as and when it is done. And if you don't go into battle with that strategy, you're not a good general. Because if you don't know the strength of your own case, how many battle tanks do you have? What is the infantry you have? What are the number of jets there are available? Number of submarines available? What is the lay of the land? What are the climatic conditions when you are going to attack? Where is the enemy's strength? What is the enemy's weakness? What is the firepower the enemy has? Where would you attack if you were the enemy? Where would you counter attack if you were the enemy? If you don't play that chess game in your mind, and if you have not done all these permutations and combinations and calculations and gone into battle, then you are doing a disservice. And that's why always my juniors will tell you 100 times they would have heard it from my mouth. Don't think of winning the battle, think of winning the war. You are in a war, you are not in a battle. Don't think of this one application, okay, today we are doing this, let's see what happens later. No, there is no later. This is it. This is your strategy till kingdom come. So it is very important that you understand that you are in a war when you are in a court of law. So these are some of the things which I thought I should talk about. But one thing I must tell you also, nobody is perfect. So please don't think that you're being lectured upon and here is somebody and the perception is that he's fantastic and this and he's so successful. Nobody is perfect. Let me tell you not. I don't even claim to be halfway there. And Mr. Nariman has once said, as you grow in your profession, the one thing you learn is how much you don't know, not how much you know. It's an ocean. The legal profession is an ocean. It's as deep as it can get. We are only practicing, and that's why it's called the practice of law. We are only learning, and we experience, and we learn from our experience. But the biggest fool would be one who doesn't learn from his mistakes. You're bound to make mistakes. Each one of us makes mistakes. But as Lord Atkin had said once, those who don't learn from history are doomed to repeat it. That is the value of learning from your mistakes. That if you don't learn when you go wrong, where you went wrong, why you went wrong, and that brings me to the next attribute which you must possess, and which is equally important, if not the most important, that is introspection. This word, I beseech you people, don't ever forget it if you are going to practice the profession. Introspect. Every single day that you are in court, you argue the smallest application to saying, my Lord, I want an adjournment, to arguing a full day's case, it doesn't matter. Go back and introspect. Think of what you could have said, how you could have said that better, how you may have done better, where you tripped up, where your opponent got the better of you, why did he get the better of you, why were you not able to answer the judge's query, where did you screw up, where did you not realize that you are likely to go wrong, why did you make an argument when you should have kept your mouth shut. Sometimes silence wins you more than speaking. Why did you open your mouth? You will go through all this. You're bound to go through all this. But if you don't introspect, if you don't learn to tell yourself and be humble enough to admit your mistakes, at least to yourself. I admit it even to my juniors, I have no ego. I tell them this is where I went wrong. I wish I had not said this. I wish this had happened. Or this should not have happened, or this should not have been said. You may not even know, you were sitting at the back, but I know that I went wrong. I should have said this. This is where I missed out, etc., etc. Introspect, you will be a better human being for you. Another thing I want to talk to you about is the use of computers. Maybe I'm too old-fashioned. Maybe my juniors think I'm antiquated, but I can tell you one thing. Computers are a resource. Don't become its slave. They are meant to help you to an extent. What I am finding, particularly from the graduates of law today, particularly from the law schools, is that they have got so used to this running to the computer at the drop of a hat and depending on Google that they have virtually forgotten the art of thinking. And the computer can never ever substitute a human being. Whatever it is, at least so far they have not substituted. Maybe they will, but at the moment it is not true. And I can tell you one thing, and my juniors will bear it out. If you don't give yourself room to think, introspect, anticipate, understand, analyze, find out why this does not sound just, find out why your case doesn't sound fair if you put it in this way, or try to build a case which sounds fair or sounds just, or what will work and what may not work. If you don't play this mind game, if you don't churn it in your mind, the computer is never going to give it to you. You may get 5,000 cases, but you will lose the case you are arguing. I can assure you of that. Because no court is a slave of procedure. No court. You can go with the binding judgment of the Supreme Court. In fact, just yesterday, one of my juniors came back and she was complaining bitterly. I went with this judgment, the most recent judgment of the Supreme Court on this point, and the judge just threw it aside. He says, don't tell me all this. You are not a collector of revenue for the government. How dare you raise this point about stamp? Document is not stamp. Now, who's going to, what are you going to do at that point of time? You may be going in thinking, I don't need to do any more work. I got this case, binding judgment, Supreme Court, what more is required? Go there, throw it in the face, go back, won the case. Never expect the judge to say, I'm not going to accept this. I don't care. What do you do at that point of time? So that's what I mean by saying, don't take things for granted. Think, put on your thinking cap. Keep thinking in your mind that what is it that will sell? Because what are we ultimately? We are salesmen of ideas. We are salesmen of thought. We are salesmen of the client's case. And if you are not a good salesman, you can never sell your product. So that's what it is. And how to pitch your product, how to sell it. Because every customer, as you know, a salesman is good. A good salesman is one who can sell his product to different people. Because everyone has their likes and dislikes. But the good salesman can make that difference, can see that difference, can find out that whereas a sales pitch worked with X is not likely to work with Y. And yet change the sales pitch and make the same product sell. So that's the point I'm trying to make. And therefore, computer is only a resource. Don't get enslaved. Keep your thinking cap alive, and very often you will find, particularly, let me tell you, never lose sight of the first principles of law. Never. I'm telling you, the day you do that, you are a loser all the way. First principles never change. First principles never change. So always keep those in mind. There are so often I have found that the difference between success and failure in a court of law is when you fall back on first principles. Not on esoteric judgments, not on esoteric principles, not on what you consider to be a binding precedent pulled out of a computer, but first principles. Then the point which I again would like to emphasize before the last point I make, this is the penultimate point I want to make, the difference between reward and duty. This is very, very important because as you go along, monetary rewards will follow if you are successful. Success brings with it a lot. It brings you fame, brings you recognition, brings you awards, brings you money, and good life. Everybody likes to be successful. Everybody likes to be rewarded. And everybody strives in that direction. But don't ever sacrifice your duty because of the rewards that you perceive you will get. Your duty, first duty is to your client, to the court, the second duty is to your client. And by that I mean, be honest. Honesty will always be rewarded. Money will come and go, but reputation can never be replaced that easily. So, yes, we all work for a reward, but that reward should be a consequence of having done your duty professionally and done it well. Don't do it because, don't practice the profession because the driving force is, I want to practice, I want to be a lawyer because I want to have a good life, I have a fancy car. I mean, then you are chasing the wrong dream. You're chasing the wrong dream. If you want to practice the profession, practice it because of what I read to you from what Mike Edwards told you. Practice it because you are the champion of law. Not because it will get you rewards. Rewards will come. They will come. They are bound to follow. But they are the consequence of a job well done. And therefore remember that try to do a good job. Try to do a good job. And why do I say there are lakhs and lakhs of lawyers? Only a few succeed. Only a few make it. There must be something different in what they do. Try to find that out. Observe. Go to court. See what happens. See what makes the difference. Why is it that some are able to go ahead and some are not? Learn by using your thinking cap, not from computers. Google is not going to give you the answer. And now I'll end by telling you what a budding youngster, and I'll here substitute the youngster with a budding lawyer, asked his Zen master a question. How long will it take to succeed in the profession if I work hard and do all the right things? Zen master said 10 years. Being a little greedy, he said, if I put in double the hours and divide the work, how long will it take? He said 20 years. So don't look for shortcuts. There are none. And you won't find them, and nobody has found them.